temporarily, and we're going to talk about the I-751 form, removal of conditional residence. If you get married to someone and you get your green card, your permanent residence card, before the 2 years anniversary of your card, you will get what we call a conditional permanent residence. A conditional permanent residence have all the rights of a permanent residence, except in 2 years you basically have to get this condition removed, and that's what many people call basically extending their green card. It's not a direct process because you have to prove in 2 years, and actually it's 1 year and 9 months after your anniversary of your green card. You have to file this form, which is called the I-751 form, and I will talk a little bit about the kinds of situations who can follow, how to file it. But first of all, it's important, if you're still with your spouse, hopefully you are, you need to file this within 90 days of this anniversary. You cannot it cannot be before the, I mean, 90 days on the anniversary of the green card, not anniversary of your marriage. So you need to file it within that, because if you file it before, it will be rejected. If you file it after, you have to explain there were extraordinary circumstances why you delayed on the filing, and just forgetting about it will not fly. It becomes very difficult then to do something which is very simple, not that simple in terms of paperwork, but not that complicated. But you want to avoid a situation where basically you will have to be faced with a lot of problems. So the form to file basically is this form. Is a form to This one is a form from for which the latest form I took from the USCIS website. As you can see, it's pretty easy. You put the name. If you have an attorney, the attorney will put all his details there. You put your name, XXX, and then YYY, and etc., and then other names used. So basically, you need to fill this. It's pretty straightforward. Country of birth on page 1, and page 2, information about your conditional residence. This is a basic information, almost bio information. So now it comes to the part, is it a joint filing? Joint filing is basically when you have a child. Let's say you married someone, and you have a child, and you want to attach a child. The child also probably got an I-751. I mean, got a conditional green card. So you need to put file one for the child too, and you need to mention this here. Now this is a part which is interesting, and I'm going to talk a little bit more about this one. Is if you are married and you're still married, things are working out perfectly for you. Only thing you have to put is that form, and all the proof from the day you start, you got married up to the date you're filing it. Proof of marriage, for example, we are talking here about bills, we are talking here about insurances, birth certificate of children you have together, pictures you have together, you name it, affidavit of friends. Just put it in there and put a very good table of contents. That should work. Now the question becomes, when the marriage didn't work out, um, or your spouse is dead, is deceased, what do you do? There will be no joint. In this case, you are allowed to file what we call an I-751 waiver. It's the same form, although before it was two different forms. Now it's the same form, I-751. You just have to tick one of those boxes. And the rule on this under the INE 216, it doesn't have the rule of 90 days before or after like the joint petition, where you have to file it within certain time. This can be filed even at a very late stage. I've filed cases after 8 years because they didn't know what to file, or things were very difficult for them, and still get in, because there are some very important rule on that, and I'm going to talk about this. It's in this memo here, where in matter of Anderson, which says you are eligible to file for the waiver, and it was terminated through divorce. You could always file it at a later stage. And I think there's another one which is called matter of Stockton, but I'm not going to mention that here. I'm not getting in really the details of the law. That you should leave it to your lawyer, but the law says you can file it even at a late stage. So going back to the form now, it covers different topics on the deceased person one, and then you have also the situation where basically you have a marriage which was entered in good faith and was terminated through divorce or annulment. A marriage which was entered in good faith and terminated to annulment, that means basically the marriage didn't work out. And at this point, oftentimes, when we reach the time, and if this happens, if you file a divorce before the 2 years and the divorce is finalized, you can file your I-751 waiver, removal of conditions, even before the 2 years rule. I repeat that. If your marriage was terminated and finalized divorce in court, you can file it earlier than the 2 years rule. But you still have to put the proof I mentioned before in the package, and make sure you prove the marriage is finalized. Now, what happens if the marriage is not completed and it's reaching 2 years? You need to file this. What you need to do, you can still file it, but within 87 days, they will issue what we call an RFE, a RFE, request for evidence. And within 87 days, I repeat that, 87 days, you have to show that the marriage was terminated. That means many times court takes some time to finalize a marriage. You need to finalize it at this point. Then there's a third category, which is entered in good faith and during the marriage you were battered. Those are for people who have been abused. Abuse has to be of extreme hardship, will bring extreme hardship, and extreme cruelty, and where they basically took advantage of you or hurt you mentally, physically, and this goes under the rule of VAWA. That rule does away with the divorce. First of all, you don't have to have a divorce. The only problem with that rule is that you have to prove extreme cruelty. You have to prove that you've been abused mentally, you have been abused either physically, mentally, sexually, or all of the above. So that's one thing, and the rest stays the same. You still put the same amount of proof to prove your bona fide marriage. You also have to put proof that you were abused. For example, doctors' letters, police reports, or a bunch of letters from friends. And this is where it's very good to have a lawyer to help you on that. And we have helped many in such cases, and we have been very successful. I'm proud of that, especially for people who have been abused under the VAWA. So, and again, you don't have to file it after 2 years. If even your marriage was 2 months into the marriage and you started getting abused, you can still file it. You don't have to wait the 2 years. And the same here is for child. If you're filing for a child, if the child was abused or your parents was abused, you can use that to remove the condition. And the fourth one is if your termination of your status would result in extreme hardship. That's another situation where you have a lot of wars now, things are difficult, and if sending you back to your home country will really kind of hurt you, you might use that. But this is not something very common. The most common ones are the four or the ones above. Usually not even the deceased. Those three, this one, and this one are the one which are really common. And in order to file this, like I said, you need what we call an I-751 form. It is here, and there's a fee for it, and you will see the fee listed on the USCIS website. And here are some memos to that effect. Those are 3 ways to remove the condition of residence. And now let me tell you one little thing that is happening. Whenever you're filing under a waiver, those cases are taking longer than normal time. The longer than the normal time means basically that it's taking almost 8 months to 1.5 years, depending how the case is prepared to get an answer. What happens if the USCIS is satisfied with your case, they will grant you your waiver without calling you for an interview. If they are not, they will call you for an interview. If at the interview now the case they are not satisfied, you will be placed under removal proceedings, where basically you have to fight in front of a judge. So be careful when you prepare those I-751 cases, removal of conditional residence, especially if you have a waiver issues. It's not an easy task to compile all this, and it has to be consistent, and you have to make sure that you're meeting the deadlines and meeting all the protocols. And just to let you know, for all those who need help when it comes to such cases, we have helped many and we will be glad to help you too. Please give us a call at 510-742-5887. And anything I told you today, ladies and gentlemen, is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. Good luck to you with your all your cases. I'll be back with another video soon.